Sarah, thank you very much. It's great to have the members who are on for the special August 10th meeting of the DASNY board. It's also great to have staff on. It's been an interesting summer. We're doing what we're doing today because it's really necessary. I hope that you all, we hope we can finish it quickly, and I'm going to do my best to get it done. But before I can start, did somebody just join?
Ms. Gomez is now joined, Mr. Chairman.
And Adrian is here as well. So all the expected board members are now with us.
Lisa, Adrian, thank you both very much for joining.
So,
We have some, I'm sorry, how are you?
good. Sorry to be late.
It's all right. Stuff happens. It's August. It is what it is. Sarah, if you would walk us through the required on the record pronouncements, we can start the meeting.
Sure. Good morning, everyone. We are meeting today via video conference and the use of Zoom, which we are authorized to do pursuant to the extension of the executive order issued by the governor and subsequently extended that relates to the ongoing COVID pandemic. So these proceedings are being recorded and will be posted to the DASNY website. The public has been made aware of the access information so that they too can join this meeting via Zoom or by telephone. And the proceedings will later be transcribed and posted to the DASNY website as soon as is practicable under the circumstances. So I will take the roll. With us today for board members, we have our chair, Al Carney, Jerry Romsky, our vice chair, Beryl Snyder, John Gardner, Joan Sullivan, Janice McKinney, Adrian Swazerski, Phyllis Morris, and Wellington Chen. For DASNY staff members, we have Ruben McDaniel, Paul Koopman, Kim Ellis, Nadine Fontaine, Portia Lee, Steve Currow, Ricardo Salomon, Jim Lapoli, John Savona, Ann Dodson, Jenna Flinton, Dina Amodio, Jeffrey Gordon, Deb Fasser, Karen Ellinger, Alex Sardine, Amanda Nazario, and myself, Sarah Richards. From Squire Patton Boggs, we have Alethea Nanku, Ed Steiner, and Samantha Casper. And I think that does it. So I'll turn it back to you, Mr. Chair.
Sarah, thank you. Again, welcome to all of you who are on the line. This will be a day that will be historical in DASNY's history. Something to be noted for years, I think, to come. Let's get to the agenda. We have the transcript of the 17 June special meeting. You all have had a chance to see it. Are there any proposed revisions? Did we leave anything out? Hearing no comment, may I have a motion, please, to approve those minutes?
So moved.
Thank you, Wellington. Is there a second?
Second.
I'm sorry?
Second, Janice.
Janice, thank you very, very much. All in favor? Well, I'm sorry, let's do it the other way. Are there any opposed to the motion? Are there any abstentions from the vote? Hearing none, I take it then that the motion passes, the resolution passes, and it passes unanimously. We're going on to the transcript of the June 22nd regular meeting. You all have had a chance to see those minutes. You've had a chance to comment on them. Are there any proposed changes? Thank you. Hearing none, may I have a motion, please, to approve those minutes?
It's Joan, I make the motion.
I'll second it, Al.
Joan, thank you. Jerry, thank you very much. Are there any who are opposed to the motion? Are there any abstentions from the vote? There being none, the motion is approved. The resolution is approved. The minutes are approved unanimously. We will go on to the Finance Committee report. Chairman Romsky.
Thank you, Mr. Chair. Finance met yesterday by way of Zoom. All members of the committee were present, and in addition, a number of board members also were present. We first adopted the meeting minutes from the May meeting of the Finance Committee, which was the last time the Finance Committee met. We approved those meeting minutes. We then advanced to discuss the one financing that's on today's agenda, which is the Raise the Age offering. And after some discussion, and which I note was all positive, and all members on the call were generally sort of excited to be participating in this offering, we unanimously recommend that be approved at the board meeting. And that sort of concludes my report, Mr. Chair. So thank you very much. Unless anyone has any questions or concerns.
Great meeting yesterday, Mr. Chairman, and a great report. Thank you. The next agenda item is actually the Raise the Age transaction. Mr. President, you're gonna introduce the presenter.
Thank you, Mr. Chairman. Good to see everyone this morning. Yes, behind tab 4, you have the documentation for the Raise the Age transaction. This is the first transaction of several that we hope to come over the next couple of months. Very important program from the state and the impetus for the special board meeting. So I will give my thanks and appreciation for the board members agreeing to participate in this meeting early. That's important for us to get this transaction moving quickly. And with that, Portia Lee will be presenting the transaction. Portia?
Great. Thank you so much, Ruben. And I too want to express my thanks to the board for having a special board meeting. This is an important initiative for the state, as Ruben indicated. It's an important juvenile justice reform initiative. And before you for your consideration is a transaction with an 18-year term for bond issuing amount not to exceed $22 million for the first bond issuance under the Raise the Age program. Albany County will be the first participant county and the sole obligor for this initial issuance. We expect additional counties will participate in the future. Raise the Age, or RTA, is a major juvenile justice reform initiative that removes 16 and 17-year-old adolescent offenders from the adult criminal justice system and places them in age-appropriate settings. The law provides that 16 and 17-year-old adolescent offenders must be separately housed from adults in facilities that are preferably located closer to the offender's home and family, with the ability to provide services in smaller, closely supervised groups. The objectives of Raise the Age include ensuring a more fair and equitable justice system, providing proper services and treatment for young offenders, as well as lowering recidivism rates. The project that you're considering will finance the costs associated with additions and renovations to the existing detention facility in Albany County. These additions and renovations will include adding a secure housing wing to provide an additional 12 beds and support space, and renovating the existing configuration to add another 3 beds. Additions will also include an exam room that will serve the nurse's suite, and in addition, off the main entrance to house administrative space, including a conference room. Proper space will be included for secure visitation, as well as additional classroom and counseling space. The secure entryway and garage will be expanded to provide sufficient space for intake procedures. The recreation yard is also planned to be expanded, as well as additional parking. And new safety and security features will also include a fire suppression system, full coverage security camera system, and an upgraded central control unit to control access and egress through the facility. It's anticipated that the bond issue will be secured by a pledge of all funds payable from the Office of Children and Family Services, OCFS, to Albany County. Those are the pledged state aid revenues. The bonds will also be secured by a financing agreement with Albany County, which includes a pre-default intercept of these pledged state aid revenues. As the pledged state aid revenues include a pledge of all funds payable by OCFS to participant counties, the debt service coverage is expected to be substantial. In addition to the reimbursement that's provided for debt service associated with these capital costs related to Raise the Age and non-Raise the Age facilities, other OCFS reimbursement includes funding related to foster care, social services, independent living, and child welfare services. Based on recent historical interceptable aid paid to Albany County by OCFS, the projected debt service coverage is expected to be approximately 11.6 to 1. The intercept mechanism is a pre-default intercept, as the financing agreement payments will be due to the bond trustee at least 4 months prior to the actual debt service payment dates. As discussed in the transaction report, Albany County owns the land on which the detention facility resides and leases the land to Capital District Youth Center, Inc., or CDYCI. CDYCI was created jointly by Albany, Rensselaer, Saratoga, and Schenectady counties as a not-for-profit public corporation, and it administers the detention facility. However, these 3 additional counties, are not obligors on the financing, and the financing aid paid to those counties is not subject to intercept. Albany County is the sole obligor for the project and will assume full financial responsibility, including its pledged state aid revenues and the corresponding intercept of such revenues for Rensselaer, Saratoga, and Schenectady County's use of the facility. Lastly, we expect the rating to be based on the intercept, and we expect it to be AA2 by Moody's. Mr. Chairman.
Portia, thank you very much, and a great job actually in negotiating this proposed financing. The coverage ratio is pretty extraordinary. We don't see that very often, and you are to be congratulated for having you and Matt for having worked that out. Let me say, and I said this in the Finance Committee meeting yesterday. If you've been in correctional institutions on the East Coast, and I have friends and family from Connecticut to North Carolina who have been in various correctional institutes, it is disheartening to see 16 and 17-year-old people, in my case, men, who are in that population of people who are incarcerated. This is an extraordinary piece of work that we are now part of, and I'm very proud of DASNY for having gotten into this, and that it's in Albany, of course, is significant. Albany County is significant in the first instance, but this is something that's very special, and I think the members should be very proud of what we're doing now, and should be very grateful to Portia and to Matthew for what they were able to do with this proposed financing. We've not voted it. I'm about to ask for a motion to approve it, but I wanted to get that into the record. May I have a motion, please, to approve the resolution?
So moved.
Thank you, Wellington. Is there a second?
This is Joan. I second wholeheartedly.
Thank you very much, Joan, and thank you for your comment. Are there any opposed to the resolution? Are there any abstentions from the vote? Hearing no comments, the motion is approved, the resolution is approved, and it's approved unanimously. Thank you all very much for this. Mr. President, I think we're back to you.
Great. Thank you, Mr. Chairman. As we know, we've been talking a lot about the Social Equity Fund, the work that DASNY is doing as part of that fund. One of the responsibilities of the DASNY board is to create a special purpose corporation. We'll be doing the second part of that work later on this morning. Appreciate everybody's involvement in that. But today at our board meeting, we wanted to have Nadine Fontaine, our general counsel, lead a discussion with the law firm of Squire, Patton Boggs, who's put together the limited partnership agreement, to be explaining to members all of the legal and structural requirements that we will be negotiating over the next couple of weeks, actually, before we bring to you a final limited partnership agreement at our September board meeting. This is an important program from the state's perspective. It is to help people who have been impacted negatively by the war on drugs historically become part of the commercial adult use marijuana environment around the state of New York. Other states have done similar programs on the licensing side. However, they have failed to assist these entrepreneurs or potential entrepreneurs in financing, and therefore those programs have not been successful. From DASNY's perspective, we are doing two things. One is assisting in the financing, and the second is assisting in the construction. OCM, the Office of Cannabis Management, is doing all the licensing work, selection work, and work on what licensees get what facilities. So our role and responsibilities really are right down the road of what we typically do in transactions. So today, happy to have Alethea Nakun, who you know from Squire and her work on the bond counsel side, Ed Steiner, who is a specialist in limited partnerships and fund development with Squire, and his associate Samantha with us today. They'll go through a formal presentation. We'll then open it up for questions from board members, both around the technical legal work. But if you have other programmatic questions, please ask those as well. As Paul mentioned, we have Ann Dotson to talk about insurance, indemnification, and board member protections. We also have Steve Curl, John Savano, and Jim Lapoli to talk about our work on the construction and real estate side of the transaction. So I think we have it pretty well covered. Mr. Chairman, with that, I'm going to turn it over to Nadine Fontaine. Nadine?
Thank you, Ruben, and good morning to everyone.
Good morning, Nadine.
Good morning. So as Ruben indicated, today we'll be discussing the proposed investment by DASNY through a limited partnership interest in a new private investment fund called the New York Social Equity Cannabis Investment Fund. As you know, we've reported on this before as part of the most recent budget passed by the New York State Legislature. DASNY received statutory authorization to invest in the fund. The fund is intended to raise money for the purposes of financing the initial build out of storefront adult use retail cannabis dispensaries throughout the state of New York for the benefit of certain social equity licensees who are selected by the New York State Cannabis Control Board and the Office of Cannabis Management. First, I will provide a brief overview of the New York Office of Cannabis Management and the New York State Cannabis Control Board. The Office of Cannabis Management was created by the New York Marijuana Regulation and Taxation Act as a regulatory structure to oversee the licensure, cultivation, production, distribution, sale, and taxation of medical and adult use cannabis throughout the state of New York. The Cannabis Control Board is the approval and oversight body of the Office of Cannabis Management. Specifically, the Cannabis Control Board is responsible for approving a comprehensive regulatory framework for New York's cannabis industry, including issuing applications and licenses to cannabis businesses and drafting and approving rules and regulations that will govern the industry. We have included a handout describing the cannabis, and as part of your materials, you should have received a handout of the Office of Cannabis Management and the Cannabis Control Board in more detail. It's important to underscore that, as you see, DASNY is not involved in the licensing process, nor are we involved in the drafting or approval of the cannabis industry rules and regulations, nor are we involved in the selection of and licensure of the dispensary operators and licensees. In addition to receiving statutory authority to select the fund manager and the general partner to form the fund, DASNY also receives statutory authority to create a subsidiary for the purpose of shielding DASNY from liability. The new subsidiary, which will be named the Social Equity Servicing Corporation, will act as an agent to the fund and the fund's operating subsidiary, which is referred to throughout this presentation as the fund operating company. The fund is managed by a third-party investment professional known as which will be the general partner, and as it's referenced in the statute. As solely a limited partner in the fund, DASNY will not be involved in the management of the fund. The DASNY subsidiary acting as agent of the fund and the fund operating company will act within the scope of the authority delegated to it under New York Cannabis Law, and with discretion only within that scope of the delegated authority. The DASNY subsidiary will have the benefit of contractual indemnification from the fund or the fund operating company in certain contracts, and will also be named as an insured, and insurance policies required to be maintained under those contracts as it enters as an agent. The New York Cannabis Law and the indemnification provisions will be discussed more fully below during Ed's presentation. So to sum up, some of this authority is new to DASNY. It's an industry that DASNY has not previously been involved in, the cannabis industry. However, DASNY's financial role is not that of an issuer of bonds, but rather of a limited partner investor in the fund. Most of the activity is more familiar. The DASNY subsidiary acting as an agent to the fund and the fund operating company will be involved in the design and build out and construction of the retail cannabis dispensaries and in the servicing of the dispensaries, facilities, leases, subleases, and loans from the fund operating company to the social licensees under the program. And with that, I'm going to turn the presentation over to Alethea to provide more of an explanation regarding the limited partnership and the investment in further detail. Alethea?
Thank you,
Nadine,
Nate.
Carney, Nadine, thank you very much. Alethea, welcome back. It's good to have you. I'll look forward, Mr. Steiner, to meeting you for your presentation.
Thank you. Thank you, Nadine, and good morning to you, Chairman Carney. It's good to see you as well. President McDaniel, DASNY board members, and senior staff. It's a pleasure to be here this morning and happy to go over a broad overview of what we're doing and the important work that will be done and answer any questions. First, I'd like to start by speaking to the important state policy backdrop of this initiative. The state of New York's principal goal in support of the fund is to benefit communities and people disproportionately impacted by former laws that punish the use of cannabis and the enforcement of such laws by promoting and facilitating the social equity licensees' access to the assets of the fund directly or indirectly, to acquire sufficient land, buildings, and equipment to properly conduct the commercial activity for which they have been granted a license by the Cannabis Control Board. Now I'd like to briefly discuss the New York law, Cannabis Law, and certain statutory changes affecting DASNY as a result of the Cannabis Law. The Cannabis Law expressly authorizes DASNY to enter into one or more agreements with the Office of Cannabis Management, the Cannabis Control Board, or a private debt or equity fund for the limited purposes of funding the capital costs associated with establishing conditional adult use cannabis retail dispensaries for operation by social equity licensees for certain purposes, including the following: leasing or subleasing real property to conduct cannabis retail dispensaries, acquiring personal property for the construction of such dispensaries, preparing plans for designing, constructing, and equipping dispensaries, entering into lease or subleases with social equity licensees, and entering into non-recourse loan or other agreements as lender with the social equity licensees. The fund is being formed for the purpose of, among other things, and whether acting directly or indirectly through the fund operating company, financing the build out of storefront conditional adult use retail cannabis dispensaries in New York State as permitted by the Cannabis Law. The dispensaries will be operated by social equity licensees selected by the New York State Cannabis Control Board under a sublease from the fund operating company as the sub-landlord, and with financing from the fund either made directly or through the fund operating company pursuant to a non-recourse but collateralized loans. In order to properly comply with the Cannabis Law, DASNY was required to select the fund manager and general partner through a statutorily mandated procurement process via a request for proposal. The deadline for the RFP was June 8, 2022. DASNY received several responses to the request for proposal, and the fund manager and general partner were announced at the end of June. Selection criteria included, among other items, organization and management structure, experience raising and managing private debt and equity capital of $200 million or more, capacity to handle the responsibilities of the fund, internal controls, and financial strength. Because the procurement process was statutorily mandated, DASNY had limited discretion when selecting the fund manager and general manager. As discussed above, DASNY will be an investor in the fund. DASNY's subsidiary will assist the fund as agent to the fund and the fund operating company with negotiating, executing, and administering all contracts related to design, build, and other contracts for the design, construction, and equipping of the dispensaries, leases and subleases required for the operation of the dispensaries by the social equity licensees, and loans to social equity licensees. The fund will also provide administrative, operational, and other support services to the social equity licensees. With that, I will now turn back the presentation to Nadine.
Nadine, before you starts out, the loans are non-recourse but collateralized. Would one of you, or maybe this is a question for Mr. Steiner, would somebody explain to me what non-recourse collateralized means?
Ed, do you want to?
Sure. The intention, the policy ecosystem is intended to give the selected social licensees the best opportunity they can to operate the dispensaries. And it was determined as a policy matter that not having the threat of personal liability as for the loans that are extended would optimize the ability of the social licensee to succeed in operating the dispensary. So unlike a bank loan where the entrepreneur not only has his or her organization, corporation, LLC, whatever, sign the loan documents, there's often a personal guarantee. There's no personal guarantee or other personal recourse under these loans.
Got it.
Collateralized means that since the dispensary is going to be built out, by the DASNY sub and the contractors that it works with, this is not a situation where the entrepreneur brings his or her own equipment, for the most part, into the dispensary. Here, getting a package, it's like a franchise package. So the loan is intended to be supported by all the tenant improvements, as well as the leasehold, sub-leasehold interest that the social licensee has. But it's intended to be a package that is intended to give the social licensee the best opportunities to succeed.
To succeed. Okay. All right. And that's very important, I think, to the members. I just wanted to make sure I was clear on it. I'm probably the only person who wasn't.
But at the end of the day, really no exposure there for the licensee, which is fine, but you should just acknowledge that, no?
Right, right.
Any other questions? Thank you, Chairman Carney. Nadine?
I just wanted to add that the way the statute was also drafted, it was important to the legislature that the licensees would incur no penalties or as a result of participating in this program. So the fact that the loans are required to be non-recourse is a requirement within the statute as well. So just wanted to make that.
What constitutes default? Not a question you need to answer now. And Alethea, it may be a question for you. It may be a question for Ed Steiner. But I don't know enough about the construct to know what default means. How do we get there?
Al, it's Ricardo. I'd like to address that. In terms of default, we haven't yet begun the drafting or the negotiation of the loan agreements. But in a typical loan agreement, failure to pay would constitute a default. And there would be other prescribed events that would actually, again, typical in loan agreements that would constitute default. We would envision that our loan agreement would contain those types of terms.
Ricardo, thank you. Thank you very much. I'm interested in sort of staying up with that. I'd like to know how those provisions, the default provisions, are being written and constructed so that so the board can know how we determine when a social equity licensee is in trouble.
I've got a different question about defaults, but I can wait till you get to the end of your presentation. Just keep me in mind.
I'd rather not, actually, but I hear what you're saying.
And the real default, really, the mechanism is really going to be the in the sublease, right? Because that's his main way to operate the business, right? I mean, that's a hammer to ensure that they're doing whatever they're supposed to be doing.
Yeah.
Because
Actually, there are two operative documents where default may occur. You're right, Jerry. One would be the sublease. The other one would be a separately negotiated loan agreement. And through that loan agreement, the licensee is obligated basically to pay for the amount that's been expended for the construction of the sites, the equipping of the sites, and the like. So there are two documents where there potentially there could be a default.
Okay. So it's more complicated than I actually realized. And thank you, Ricardo. I know you're on top of this. That's not the issue. I'm just trying to make sure that I have a bare bones understanding of the process. Also, I have not yet received, I asked Nadine, and maybe it's coming, maybe it's not ready yet. I don't understand, and Alethea, you just walked us through it. So did you, Nadine, but I need to see it. I'm visual. The clear relationships between the Cannabis Control Board, the Office of Cannabis Management, and any corollary ancillary organizations that operate around those two legislatively created organizations. Is that coming? Can you all send that to me?
I could send you there's a governance document which identifies the role of those two entities. So the Office of Cannabis Management is a department within the State Liquor Authority, and they are the agency that is responsible for the oversight and licensure of the cannabis program. The CCB is their board, and they have oversight over the Office of Cannabis Management. So it's only the two entities. And the actual day-to-day operations that are conducted by the office. Sorry, Jerry.
Is it possible though to maybe put it in some type of like a visual, like a flow chart?
Of course.
And it maybe the comes in just to sort of like see the visual nature of it. I've sort of done it sort of myself, and it's it's a little bit of a there's a lot of players in this one, and it just might be easier just to visualize it a little bit. I realize it's not, and it's complicated, and it's done by the legislators, so like they set this thing up. But I was just a little how the fun fits into the whole thing. That's all.
Of course, not a problem at all. Not a problem.
Let me ask you, perhaps the lawyers at Squire, a specific question about the partnership agreement. So the DASNY subsidiary would become a limited partner in this partnership agreement. And our draft contemplates that our general partner, SWS Capital Management or its affiliate, is going to look to raise about $150 million of private investment. And that in section 3.3 of this agreement, we are going to contribute 25% of the target amount that SWS raises, which means that we would have to come up with, if they raise 150 million, $37,500,000. Am I reading that right?
No, the intention, I think, is that it's actually DASNY that's going to be, as opposed to the sub, that's going to be the investor according to the statute. So DASNY is investing the up to 50 million. The intention is that on a post all the money in basis, DASNY is 25%. So if they raised $100 million, what's 100 is 75% of what? As good as math, 133. So DASNY would put in 33.33 million if they raised 100. So if they raise 150,
that's exactly right.
We do 200. So and the 2 points there are that if they do raise the full 150, we put in our max 50, and it is DASNY as opposed to the DASNY sub that's actually being the investor. The DASNY sub does all the blocking and tackling with respect to acting as the agent to the fund and the fund operating agreement, and negotiating, and handling the construction of the dispensaries, and subsequently in loan and lease servicing. But
so what I'm concluding is that if for some reason DASNY couldn't come up with $33 million, we would be in default under this limited partnership agreement, and we could be sued by these private investors.
Well, John, just so we're clear, the $50 million that DASNY is committed to maximum investing has already been appropriated by the legislature and is sitting in the account waiting for DASNY to invest it. So that money has already been appropriated by.
Right.
And they probably needed to close the fund. Like they probably won't have a closing on the fund until everybody's money is in.
Yes.
Until all the money.
And that's well and good. I would like this partnership agreement in any place where DASNY could potentially default and have exposure to private investors to be contingent upon state funding. So, for example, the way that Section 3.3 would work is that provided that the allocated funds are made available to DASNY in order to make this contribution, DASNY will make the contribution. But if for some reason there is some glitch in that process, DASNY would not be in default to these private investors.
John, I understand. Typically what we do, and it's language that we've included in other provisions, we include a statement that the investment is subject to appropriation.
Yes, absolutely. And there is no exposure to DASNY if it doesn't happen. This is, I'm working a little bit on one foot because, as I mentioned earlier, my computer has crashed and I can't get at my notes. But my general comment, is that I think it might behoove the board to have its own counsel look at this, because in a number of things that I've seen related to this so far, I think what we have is Squire is acting as sort of counsel to the situation. And that's fine. I have no, that's, Squire can do that and they're doing their best, but we have, DASNY has its own interests to protect. And I'm not sure that, I'm not, I'm not slighting Nadine in the least. Nadine works for Ruben, and Ruben is on two boards here, not just DASNY, he's on the cannabis board. I think the board of DASNY should engage its own counsel to look at these things. I don't want to be the lawyer to the board of DASNY, but I do see things that if I was the lawyer to the board of DASNY, I would raise. Like this.
John, it's Al. First of all, Mr. Steiner, are you going to do a separate presentation?
Yes.
Well, then why don't we, John, you may be right. I mean, and I frankly am directionally headed where you've already arrived. But I want to hear Ed Steiner's presentation just to see if there's a comfort level that I acquire, that you may acquire as a result of that presentation.
Could I just make a statement though before we move to Mr. Steiner? It's, my position as general counsel is not just attorney to the president of DASNY, it's also as counsel to the board. So I just want to make it clear that my interests are not, that I'm not solely representing, one interest here. And, I just wanted to make a statement on the record that I am representing the board as well as the president and the organization of DASNY. So just want to make sure that that's clear on the record.
John,
I didn't want to suggest otherwise. Absolutely agree. Absolutely. And you do an excellent job.
Okay, there you are. Nadine, thank you for that comment. And it is on the record. And it's, I don't want for anyone, but we've not arrived at a place where there is an obvious conflict. And as long as we're not there, then the legal staff of DASNY, which is obligated to represent the board as well, until we reach a point of some conflict, then we're fine. There's no question. If we get to the point where there's a conflict or an apparent conflict, then we have a decision to make. But we're not there yet. So let's.
Al?
I want to wait, please. Let me. Yeah. I want to hear Mr. Steiner's presentation. Ed, you're Ed or Edward? I don't remember, but
anything but Fast Eddie. Okay. I mean, having dealt with conflicts that arise with internal lawyers and boards in the past, I mean, I may not know, but I have a sense of where the two begin to diverge, and we're not there yet. But what I do want to understand, Mr. Steiner, is this limited partnership agreement that you're going to tell us about. Again, our involvement is right now solely with regard to retail facilities and with build outs and putting and personal property and that sort of thing. I want to understand that clearly before we start to take off and do different things. John, I appreciate your comment because we could get there.
I'm going to take issue with you when I have a chance.
Well, when you have a chance, let's do it. Let's do it after the meeting.
Okay.
All right.
Mr. Chairman, before Ed speaks, just one housekeeping item. The Social Equity Servicing Corporation board meeting was scheduled for 10 o'clock. Several members of the public have begun to join us for that meeting. I just want to let them know we're still in the DASNY board meeting. The Atlantic Avenue meeting will have to happen after that. And then right after that will be the Social Equity Servicing Corporation board meeting. So I just want to let people who are wondering where we are in the meeting, give them the update. We will have the SESC board meeting coming up shortly. With that, Ed, would you go ahead and take your presentation?
Certainly. Good morning to all the board members. This project is being done within the statutory framework that Nadine mentioned and within the policy ecosystem that Alethea described. I'm going to talk about the nuts and bolts of the fund. The project unfolds in two distinct phases. First, phase one. The fund itself will be a limited partnership under New York law. Social Equity Impact Ventures LLC has been selected as the general partner, and there will be two limited partners initially, DASNY and the Impact Ventures LLC. They'll enter into a limited partnership agreement, and SWS Capital Management LLC will serve as the fund manager. Limited partners are managed on a day-to-day basis by the general partner, not by the limited partner. So DASNY is a limited partner, and the fund itself will be managed by the general partner with certain decisions and determinations to be made by the Public Policy Committee. That committee is comprised of the chair of the Cannabis Control Board, the executive director of the New York Office of Cannabis Management, and the president of DASNY. The Public Policy Committee will advise the fund and the fund manager with respect to matters that implicate public policy goals and concerns that emanate from the cannabis law and its implementation in the program generally. The Public Policy Committee will also provide advice and direction to the fund manager where investment and credit matters implicate public policy matters to ensure that they're resolved in a manner consistent with the objectives of the New York Cannabis Law. It's important to know that the general partner, even in this initial phase, will have contractual fiduciary duties to the fund and the limited partners, including DASNY. In phase one, it's anticipated that DASNY will contribute a minimum of $4 million to the fund pursuant to the initial limited partnership agreement. I want to really stress the fact that there are going to be two limited partnership agreements. The first one does not involve the public investors. This is simply an agreement between the general partner that we've selected and DASNY as a limited partner investor. It does not involve the outside private investors. The maximum that the state through DASNY can contribute to the program is $50 million. In the initial phase, the other limited partner, that Impact Ventures LLC, will contribute a minimum of $4.2 million to the fund. Again, the maximum, this is like a minimum maximum offering. The maximum that all limited partners will put in will be, private limited partners will be $150 million, with DASNY's maximum $50 million. The closing of the initial limited partnership agreement, again, this is like the bilateral one with DASNY and the general partner, is referred to as the initial closing and will occur as soon as practicable. The initial limited partnership agreement will require the fund to contract with DASNY or the DASNY subsidiary as fund agent to take such actions that are necessary to establish, construct, and equip 3 or 4 dispensaries. These actions may include site selection, negotiation, execution, and administering design, build, or other contracts for the design, construction, and equipping of the dispensaries, negotiating, executing, and administering leases with landlords for dispensary facilities, and obtaining all necessary or appropriate permits, licenses, authorizations, and arranging for customary insurance coverages. These actions are expressly authorized and permitted pursuant to the cannabis law. As the fund is working on establishing these dispensaries, the fund manager, again, the fund manager, not DASNY, will be developing an offering package to be utilized to attract private investors in connection with the second stage of the transaction, which we'll describe later. Obviously, liability exposure is important to this board. Losses, liabilities, and expenses incurred by the fund in the initial phase are allocated among the limited partners in proportion to their capital contributions. However, DASNY will not be liable or subject to any loss, liability, or expense of the fund beyond the amount of its capital investment, which is a minimum of $4 million in the first phase. Again, the structure of a limited partnership is that the general partner has unlimited but secondary liability for the obligations of a limited partnership. The limited partners are liable only for the amount of their capital contributions. In that way, the limited partnership structure approximates the corporate structure where a stockholder is only liable for the amount it paid for its stock.
Got it. Okay.
Next, indemnification and insurance. Several types of indemnification are going to be talked about here. One is the typical thing in a contract where here DASNY sub is acting as an agent for the fund. Let's say it's the first party, and it's going to do things on behalf of the fund. If and when DASNY sub is sued, perhaps out of a contractual relationship with one of the counterparties, say a landlord or whatever, there will be an indemnification from the fund to DASNY sub in its capacity as agent. And that's as we all know, fairly typical in the commercial world. So that when you have an agent, the agent acts within the scope of its authority and it's doing your business, and that agent gets sued on your behalf, you are going to indemnify that agent. And that's going to be taken care of in both the contracts, the agency contracts between the fund and DASNY sub and otherwise. The second form of indemnification is within the partnership itself. General partner or the fund manager or their representatives and agents, including the DASNY sub, may be defendants in litigation relating to the fund. In some circumstances, the fund and not DASNY or any state entity will indemnify, defend, and hold harmless the general partner, the fund manager, or any of its representatives, affiliates, or agents, including DASNY sub as agent, against the cost of litigation, including legal fees, unless the conduct that prompts the litigation constituted fraud, breach of fiduciary duty, willful misconduct, bad faith, gross negligence, or material breach of the law.
It's gross negligence, Mr. Steiner?
Yeah.
The standard is gross negligence? Okay.
That's pretty much market.
Okay, no, I'm just.
No, it is. It's a good question because that's one of the big wrestling matches you have. On the one hand, the standard of care that's talked about all the time is always a prudent man or prudent person standard, which implies simple negligence. But the scope of liability typically is based on gross negligence. This is a trend that emerged in the mid 80s when I started practicing law, where in Delaware, the standard under the business judgment rule was simple negligence, but the standard for liability of the duty of care was gross negligence.
Okay.
And the situation is the same in New York. You have a standard of conduct which is arguably more strict than the standard of liability. And so that's, the nuance here, that typically people are indemnified unless it's gross negligence.
That's why I raised the question, Mr. Steiner. I saw that it's sort of an incongruity, but you've just explained it. I understand it. And the business judgment rule, I guess, hasn't changed. I mean, I used to be a lawyer. I'm not very proud of that. I call myself a recovering lawyer. But
I aspire to that status.
But I did do a bunch of work on the business judgment rule with Delaware courts, and I thank you for taking a second to make that distinction. It's nuanced, but it's there. Thank you.
Okay. And finally, in addition to indemnification in its two phases, you have insurance, and the DASNY board members are covered under DASNY's blanket policies, which include D&O insurance. And additionally, the members of the new DASNY sub will also be covered by that insurance package. There is a chart. I don't know if you have the chart.
I don't have it.
Sam,
don't worry. Somebody will get it to me. I'll get the chart.
Okay.
Actually, Amanda's going to put the chart on the board, on the screen.
Okay, great. Thank you.
While she's doing that, Ann, you're on the phone. I've never asked you to talk to the board about the extent of the insurance that DASNY members have. And I don't want to do all of that now, but might you take some time with me tomorrow, the day after, to just walk me through that so that I understand the coverages?
Absolutely, I'd be happy to.
Thank you very much. And anybody who wants to, I don't think there's some limitations as to how many of us can sit with Ann without making it a board meeting. So, Nadine, you and Ricardo will know about that. If folk want to join, if Ann and I can set up some time and you're available, it'd be great to have you on the line so that you will have heard it. All right, I got the chart. Ann, thank you.
This is this is the initial closing, and you'll see at the top is the general partner, and on the left side is SWS, which is the management company or the fund manager. We've got the fund in the middle there. The fund will form for its own liability channeling purposes a fund operating company. I should mention that the general partner of the fund will effectively manage the fund operating company, as the fund operating company will have a single member and a single manager, which is the fund itself. So the fund is managed by the GP, so the fund operating company will also be managed by the GP.
And
You've
is
got-
this,
Go ahead.
is this the same setup for both phases?
No, this is just phase one.
Okay, and but that's what DASNY's putting in basically all of the money, no?
This is where
$4 million.
$4
Right,
million.
and the fund is just doing a letter of credit in 200,000. Right, or no?
They have to put in more than we're putting in, and I don't know that we've settled on how much is cash and how much is letter of credit.
Okay.
That's still,
Ricardo,
that's
you'll,
still a jump on.
Whatever.
Ricardo, you'll let us know what the ultimate decision there is.
That's right. But as Ed indicated, they will always be the majority partner, even in that ramp up phase, the first phase. So it may be 4.2, it may be 4.4, but it will always exceed the amount that DASNY has contributed in the first phase.
Ricardo, it's a letter of credit, right? In the first phase, letter of credit. It's not. He's not check before.
It
No,
may
but
be.
it's
It may be a letter of credit, Jerry. I think what I'm hearing is.
No, well, the expectation is that it will be a letter of credit. But that letter of credit, again, to the extent that we go through the capital that DASNY has contributed, we would be able to draw on that letter of credit. So it is capital.
Okay, all right.
And the amount is still subject to negotiation.
Yes, it's still subject to negotiation.
Make that clear.
A capitalized letter of credit. I like that, actually. There are other board members on the call. Mr. Steiner, may I call you Ed? I'm Al.
Yeah, Ed's fine.
Okay. Ed has just walked us through. I don't know that you're done, Ed, but there are other board members on the call. Do any of you have questions for Alethea or Ed based on the reports that they have given?
This is Joan.
Yes.
Well,
The report is not concluded.
Joe.
Mr. Carney, can I just add one thing? Ed just provided an overview of the initial closing, and we've got the chart here. He also has further in his presentation, we'll talk about the second fund development. So I don't know if you want us to finish his prepared comments first and then go into questions, because there may be questions that the second portion of his presentation could adequately answer.
Thank you, Alethea. Let's come, Mr. Ed, would you complete your presentation, and then I'll ask the board members again if they have questions. This is dense stuff. It's where the reason that I wanted to give the members an opportunity, Alethea, is that the lawyers on this board probably have a better sense of where this is directionally. The non-lawyers on the board may have questions that are all over the map, and I just didn't know whether at that point anybody might have questions for Ed. But yes, let's finish the presentation.
Okay. Absolutely, and please stop us if there's something, because you're right, this is very dense. So if to the remainder of Ed's presentation, if you want us to pause.
No, Ed, thank you. Go have at it.
Okay, so the only thing I'd say about this slide about the initial closing is that you can see it's really just DASNY, the DASNY sub, and the general partner involved. There are no third parties other than the third parties that the DASNY sub, acting as an agent to the fund, will enter into contracts with for the design, build, leasing of the initial 3 to 4 dispensaries. So we'll go on to the next phase. The next phase is going to be much more typical of an investment limited partnership. After the fund and the fund operating company have been formed and the initial LPA has been signed, the fund and the fund operating company and the management company will commence with DASNY's help, commence the process of identifying, designing, building out, and equipping the initial dispensaries. While these are being designed, identified, and built out, the general partner and the fund manager, not DASNY, will seek to identify private sector investors become limited partners in the fund, and will create a fundraising document in connection with the private sector investment. DASNY will have no responsibility for identifying private sector investors or for preparing the fundraising documentation, other than approving any references therein to DASNY, the DASNY sub, or to the state's role in the fund. So the promoter here, if you want to put it that way, is the general partner and the fund manager. DASNY is not in that role. The private sector investors will be unaffiliated with the fund or DASNY and will be up to 95 unaffiliated investors. These private sector investors will be known as the Class A limited partners. After they've been identified and committed to invest at least $25 million in the aggregate in capital commitments, and further satisfied all the relevant legal and regulatory requirements, the general partner and or the fund manager will organize and schedule a second closing. So we're saying that we won't do a second closing until we at least get 25 million in aggregate private investment. But again, it could be up to 150. And the initial capital call made in connection with that second closing is intended to raise investment proceeds for the fund in an amount necessary to fund all the fund's anticipated operating expenses for 90 days, the amount needed to fund a reserve account, and the amount needed to pay for or reimburse fund organizational expenses.
Ed, it's Al again. Help us to understand. You would have a closing after a $25 million after $25 million in investments by private investors. You would then open, in effect, a second fund. That second fund you would anticipate it to go to the difference, whatever that difference is, up to $150 million. Am I correct about that?
Well, the way to look at that is the initial limited partnership agreement, which is again just between the GP and its affiliates and DASNY sub, is going to be superseded. The documentation that the fund manager and the GP will create will include what we're calling a marketing LPA, which will be more or less standard in the business for investment private limited partnerships. It's intended to be more investor friendly than our bespoke thing from the first initial closing. It'll have customary terms and conditions you'll see in a typical limited partnership agreement for investors. And so the magic of what happens is at that second closing, and again, 25 million is the minimum. That's not what we hope for. Because we only get 25 million at the second closing, we're going to have to get subsequent closings in order to get money to really build out according to the plan that the legislature contemplated and that the policy environment dictates. We're not talking 3 to 4 dispensaries or even 10. They want up to 150. So if we only do 25 at the second closing, we'll have to have subsequent closings, and there is a mechanic for subsequent closings that's traditional in investment limited partners, where let's say we do 25 at the second closing, and we have a subsequent closing of 50, we have a mechanism for tax and accounting purposes to treat those 50 million that come in subsequent as though they invested at the beginning, and they will bear their pro rata share of the charges from the beginning. They're not entering in sort of on a blank slate.
Okay.
So in any event, and the structure that's important here is that the private money comes in as Class A limited partners. The unique marketing advantage here is that DASNY as an investor is going to be a Class B limited partner. They bear the residual risk of losses up to the amount, but no more than they put in as capital investment. So if it's fully subscribed and we have a $200 million fund, basically DASNY as a Class B limited partner bears a disproportionate amount of the losses because they're subordinated. They're a subordinated limited partner, and that's the attraction that the GP and the fund manager will market to the private investors. So the Class A to the public, Class B for DASNY structure is important. And the maximum commitments for private investors will be 150. So the total fund is 200 million. The fund will stop accepting capital commitments on the dates earlier of 24 months from the initial closing or when they've gotten the 150 of private sector commitments.
Okay.
We talked about subordination. So that's really one way in which DASNY as an investor has exposure. They're not exposed for the day-to-day management because that's the GP. They are exposed because they bear a disproportionate amount of losses up to the amount of capital they contribute. So again, if it's a $100 million private sector investment, the DASNY sub has 33 million at risk, and they bear a disproportionate amount of the losses. The indemnification structure is going to be similar as between the GP, the fund manager, and their agents, including the DASNY sub, as in the initial phase. There's really no change there. And maybe we can just go look at the second chart, Nadine, and we can just look at that right now. So the only difference here is that you now have in the lower left-hand corner, you've got the private investment money, and it's no longer just one class of limited partner. You've got a Class A limited partner and the subordinated Class B limited partner, which is DASNY. Otherwise, the structure is equivalent, and the nuts and bolts of operations stay the same. The fund is managed by the GP, not the LPs, not DASNY is the subordinated LP, and the fund operating company is also managed by the GP. And the management occurs within the policy ecosystem that has been established and that will be, if you will, enforced by the Public Policy Committee through decisions and determinations.
I want to thank you for both charts. I am visual, but I need to spend some time with them. It is Al again, just to try to understand the flow. I'm not, you've just explained it, Ed, and I may want to call you on the phone and ask you to do it again, but I need to spend some time with it.
No problem. And I think that's really where we are. Again, just to sum up, the initial closing, which will happen as soon as we possibly can, is really an internal deal between the DASNY as the limited partner investor and the GP and its affiliates. And it's an interim phase. We're trying desperately to, have funding so that we can build out the 3 to 4 dispensaries. And the second closing, which is what is more familiar to everybody, is the real investment closing, will amend and restate this very bespoke initial limited partnership and replace it with a sort of investment standard limited partnership agreement, which has really one very different structure, or feature, which is the subordination of the DASNY limited partnership investment to the investments by the private unaffiliated partners.
Investors, unaffiliated private investor. Okay, got it.
Can I ask a quick question? That public policy committee, which clearly plays a significant role in sort of the operation, and frankly, a very important role, at least to the extent I understand this. The members of that committee, are they been designated by the statute? I haven't really dug into it that much. The actual members, where they come from, the cannabis board and from DASNY, is that where that setup comes from?
Correct. Yes, it's designated by statute. It's those individuals or their designated representatives.
Thank you. And the other thing,
Nadia, how many are there?
There's
The
three.
three, there's three specifically named in the statute. There is no limitation or specific indication on how many designated representatives should be accounted for each individual, but it's anticipated that it would be one representative for each individual.
Named individuals. Okay, thank you.
Al, could I ask a couple of questions?
Yes, Jim.
Thank you. When I first reviewed it, it appeared to me that phase one, the success of phase one was a trigger for phase two. But what I hear you saying is phase one is put in place to expedite the development of these initial dispensaries, right? It's
Right.
not based, and phase two is not based on the success of phase one.
I think what phase two is really the definition of success. Do we get enough private money to make the program really work the way it's intended to work? Phase one was to accelerate,
Right.
so that when they're marketing, they can point out to, well, here's some dispensaries that are being worked on, the project's ongoing. I think the initial phase is basically two things. One is proof of concept, and secondly, it does aid the fund manager and the GP in the marketing of the. It helps to have something there that you can point to.
Right.
And Ed, the third, just to be clear, the third reason we're trying to do a couple of these facilities quickly is so that as licensees are selected, the Office of Cannabis Management has some facilities to do workforce development training, operations training, and other types of training, so that as the facilities are built out, they can quickly get licensees in those facilities, having understood all of the processes, procedures, and standard operating procedures of a facility.
Hey, Ruben, I guess
my second question, oh, sorry.
No, and I'll come right back, Joan, while it's in my head. Ruben, the objective is to do obviously as many as you can on the first round, but what are you guessing? Like how many you think I guess it depends on the lease and all the build out costs too, right?
In phase one, we're targeting between 3 and 5, depending on whether they are city or rural. But given what we're looking at now, we are looking at 2 or 3 in Manhattan/Brooklyn that we're very close on. We have one in Rochester we're very excited about, and one in the Buffalo area we're very excited about.
Great. Sorry, Joan.
No, that's okay. My second question is, we talked about DASNY's exposure, and it's notwithstanding appropriations, where if it's not appropriated, we're not liable. What happens if the legislature fails to appropriate up to the 50 million? Does this whole deal fall apart?
Joan, the legislation has already appropriated the 50 million.
Oh, they have, so they don't have to reappropriate next year.
Correct.
Got it.
Correct.
Okay, thank you.
Thanks for your questions, Joan. Ed, are you at or about worn out now?
Ed, I've got a question for you.
Okay.
John, you're back.
Oh yeah. I have a bunch of questions, but this is really the primary one. On the indemnification, is it clear that DASNY is primarily responsible for indemnifying board members, or are board members looking to the liability insurance for indemnification?
Well, I think it's a question of where the claim comes from. If it's, let's say it's a DASNY subsidiary who's servicing a loan or a lease, and there's a claim by someone, they slip and fall, and they sue everybody in the room. They sue the fund operating company, which is the sub landlord, if you will, and they sue DASNY sub for having arranged some things and maybe for servicing. In that case, DASNY sub and hence derivatively DASNY should be protected by its agency contract with fund operating company or the fund. That's one layer of protection. And that's internal to the sort of the nuts and bolts documents. And there should be some insurance that the dispensary operator is required to carry. And there you would think that we will require the dispensary insurance coverage to name DASNY sub, the fund operating company, everybody and their mother as additional insureds. So in that kind of context, that's one layer or nexus of contracts there. The other one is if it ever gets up to the fund level, the fund is obligated to indemnify the agents of its agents that are doing things for it, which would be the DASNY sub. So there's really two things. There's the fund document itself, which is got one set of indemnification structures, and then you have the operating contracts where you're going to have insurance and contractual indemnity outside of the investment world. But you're going to have really two levels.
Let me react to your response. We are being asked to get into a limited partnership agreement and play a role that we've never played before. This is a business deal. And my question really is that my comment, there should be a very clear understanding that if any individual member of this board is named in a lawsuit, whether it's from a third party who slipped and fell, or whether it's from a private sector investor who is a party to the limited partnership agreement, the indemnification should come first from DASNY. There should never be a situation where a board member could be vulnerable to an insurance carrier denying coverage or questioning coverage. There should never be a situation where a board member has to pay a deductible. The primary indemnification should come from DASNY itself, and then to the extent that DASNY can collect from a carrier, good. That's what we want. But the board members should not ever have to get that far. That's a comment. I don't think that kind of protection exists for the board members. I haven't worried about it to date because in the various areas that we operate, I just haven't seen the need for it. But this is a business deal. And to my earlier comment, and this is where Al and I perhaps disagree, I think we need to beat it up a little bit as any party would enter into a business deal. Not a lot, but a little bit.
John, first of all, thanks for your comment. We don't disagree so much. We just, you and I and Jerry potentially simply need to get a bit more information. It's why I wanted to see the flow charts, and I need to study them so that I can understand first of all, where the obligations are, and then where we are as the SESC subsidiary board. I need to spend some time, and we have a month to try to get that done. Well, not a month, we have until the 7th of September. But it's, what I just learned was that I need to bear down hard to understand what our obligations are. I still don't clearly understand our risks, but that doesn't mean that we are at risk. It means I don't understand yet what they are. You and I will spend some time together. I'm not coming to Buffalo, John. So you know, maybe we can, I'm not even coming halfway to Buffalo. So you know, but we need to spend some time on a phone call, trying to understand as clearly as we can where the risks are. I mean, Ann's on the phone. You know, I don't know whether our insurance coverages are out front or reimbursable. And I don't like the latter. The latter is not where I want to be. So I just need to study the charts. I may need to talk to Ed. I certainly am going to have to talk to Ann. Ann, I'm sure you have spent some time looking at this, but this, to John's point, this is a business deal. This is not what DASNY has done in the past, at least to my knowledge. We're doing something very different here. Nothing wrong with it. The social equity component of it pleases me immensely, enormously. That said, I don't know what the risks are yet. I just need to spend more time thinking about it. And Nadine, thank you for helping us to defer this meeting until September.
And I also have a question. It's
Hey,
what
Bill.
are our responsibilities exactly in our role with respect to the first closing? I'm also unclear what we are doing as a board as far as reviewing. Are we reviewing each of the projects, or what, I mean, it is the flip end of the responsibility. It's the liability is what we're responsible for, and therefore what we're liable for. So I would just, not necessarily on this call, because I know I, for one, am a little pressed. I only am here for another half hour, but I'd like to really understand what we're doing after the first closing.
Well, it does not include approving each dispensary location or anything like that.
Because that's already done. That's done by the cannabis board. I get that. So what are our responsibilities besides?
I think you put $4 million in.
Besides that, but that's it. That's it. We're just like we're a limited, again, I agree with you. It's a business deal. We're a limited partner. We put the money in and we say goodbye. And
Well, unlike a limited partner, unless I misread this, there's no real investment. You're not getting a gain on it. You're basically putting I think, right? And we keep on being called an investor, but we're really a distributor, right?
I think the thinking here, Jerry, is that we would basically be receiving a nominal return. But to your point, this is set up, the subordination is set up to advance the public mission that we've spoken of. It's an important element here in order to attract the capital necessary to build out the dispensaries and equip them in the fashion that the state envisioned. So yes, in terms of our investment, it's subordinated. We're not receiving the same return that the other private investors are receiving, but that's all by design to advance the public mission.
You know, I get it. I agree 1,000% with the mission, but I'm just saying we keep on being called the investor, and typically an investor gets funds. So what we're really doing, we're putting $4 million in, right? The fund really isn't putting 4 in. We can have that discussion about the letter of credit, but it really is our investment into this to make sure this thing gets taken off the ground and it's successful, which is a good thing.
My guess is if there's exposure, it's more on the property end, as somebody was saying earlier, the slip and falls, somebody came in and let some underage somebody buy something, as in the sublease structure is probably, I would guess, where our risk will really, our exposure will lie.
For the first phase, Lisa.
Yeah.
Well, it gets much more
I agree
complicated.
with that.
Second phase,
You're right.
sort of exposure sort of pops, I think, but but you're right. On the first phase, the connection with the subleasing documents really becomes important from a sort of. Then I would agree with you on that.
That's right. We wear two separate hats here. We wear one hat as the investor, and that's DASNY making a direct investment into the fund, and that risk is basically capped at the amount of the investment that we basically make. And it's also subject to whatever we subscribe to. I know I didn't touch upon that, but there's also a subscription period, a subscription agreement that would be signed in connection with each closing. So it's whatever we've committed to, yes, we would be on the hook for, but that's DASNY as the investor. Then we wear a separate hat in terms of the subsidiary, acting as an agent for the fund in the administration of various services, including leasing, loans, and other property management services, as well as construction management services. That's a completely separate hat, and that hat is worn purely as an agent. And I know Ed went through that, but I just wanted to underscore that.
What about the design build component of it? The DASNY subsidiary is the owner on that contract? Like the design, build, I'm missing it, but I thought it was like a design build job where we go in, you identify this dispensary location wherever it is at Rochester, wherever. And then, okay, now you're hooking up with a design builder and you're signing an agreement with them. That's signed but that's signed by the DASNY subsidiary, right?
Correct.
Well,
As agent
Correct.
As agent for the cannabis board or something?
As agent for the fund, I
Fund.
think, Jerry.
As agent for the
The
fund.
Social Equity Servicing Corporation will serve as agent for the fund. And we will be entering into a construction advisor agreement, construction management advisor agreement with the fund to identify what our roles are, and also, as Ricardo has indicated, which will include the indemnification provisions that will shield the subsidiary, the DASNY subsidiary, from liability. And just to make a correction, it's the fund subsidiary. There are two subsidiaries that we're dealing with here. The fund has an operating entity, and then DASNY also has a subsidiary, our social equity subsidiary corp, servicing corp, which will shield both entities from liability.
DASNY is not signing the design build agreement with the actual design builder. DASNY or its subsidiary, neither of those entities. We are simply the agent.
As
It's
agent.
like a classic CM agreement, not a CMGM where you just.
Exactly, Jerry. Exactly.
Correct.
Yep.
But that liability is the same regardless of whether it's in this type of a transaction or other types of transaction, the slip and fall. I mean, that is.
Correct.
Okay.
Folks, it's 11 o'clock. We're way over time-wise. A lot more to be said, and I've just got to spend some time with these charts. Thank you, Nadine, for getting them to me.
Sure.
Are there any questions before we go on to Kimberly Ellis? Are there any questions that you all have for Alethea or Ed at the moment? It's not to suggest that you won't have questions, and it's not to suggest you can't reach out through Nadine to make sure you've got your answers. But are we at a point where we can move on now?
Sure.
And I just wanted to reiterate that I am available at any time. I could provide my cell, my phone number, via email if anyone has any further questions. I just wanted to make sure that people were aware of that.
There will be further questions, Nadine. The real question is, are they for you or are they for the people that you brought in to help us understand the deal?
And Ed and I are happy to continue the discussion and answer any questions as well.
I knew that, and I appreciate your saying it. Thank you. All right, so the next agenda item is investment policy and guidelines. I'm sorry, Alethea, Ed, thank you both very much for taking
Thank
as
you.
much to have with us this morning. And looking forward to, haven't seen you in a long time, Alethea, never met Ed, we'll figure it out.
Okay, thank you all.
Thank you, everybody.
Bye-bye.
Thank you.
Bye-bye.
Okay, is Kimberly there?
I am.
Well, ma'am, the floor is yours.
Thank you, Mr. Chair. For your consideration is a resolution where we're requesting exception be made to DASNY's current investment policy and guidelines. Section 8 of the guidelines allows the board and treasurer to specifically authorize other investments that are consistent with the overall objective of the program. This exception is being requested to allow the investment into the New York State Social Equity Cannabis Investment Fund, which is the private credit fund that's being established to advance the state's initiative to cover the capital costs associated with establishing the adult use cannabis dispensaries. Our current guidelines does not allow for investment in a credit facility, so this resolution will is looking to allow us to invest up to $50 million, which is being provided by the state to invest in this fund.
Kim, thank you. I assume you're at the end?
Yes.
I mean, we've all seen the resolution. The members have had a chance to take a look at the proposed resolution. Are there any questions about it? Hearing none. May I have a motion, please, to approve the resolution?
So moved.
Thank you, Wellington. Is there a second?
No one wants to move it.
Gerard, thank you very much for the second. Are there any opposed to the motion, to the content of the resolution? Hearing no opposition, are there any abstentions? Hearing no abstentions, the motion is approved, the resolution is approved, and it is approved unanimously. Because this is a special meeting, there are no management reports at this meeting. And unless there is further business to come before the DASNY board special meeting, I'd like to have a motion to adjourn.
I make the motion. It's Joan.
Thanks, Joan.
I'll second it, Beryl.
Thank you, Beryl. It's been properly moved. Seconded. Is there any abstention? I'm sorry. Is there any opposition to the motion as offered? Hearing none. Are there any abstentions? Hearing none. Well, we are adjourned unanimously. Okay.